I'm someone who has been involved in strategic litigation almost all of my working life. The issue of judges and the relationship between the media and politicians has clearly changed in the last 30 years, but I'm old enough to remember, particularly on social security cases in the 1980s, the issues of the goalposts moving the next day, some of the controversy around judicial decisions and how they were responded to politically. I can remember some important cases around immigration and human rights in both the 90s and the noughties. And I suppose one of the reflections is politicians' views of judiciary are not confined to one particular form of political colour over the years. What I think has changed very significantly is the move into the social media era, and therefore how judges and their decisions are viewed and discussed has changed over time. For me, there's no better person to offer an observation and analysis of how that's changed than somebody who has been watching this and at the crucible of it for many years, and that's Joshua Rozenberg. So without any further ado, I'm going to ask Declan to speak first and introduce our speaker. We'll then have a lecture for half an hour, and we will have time for a Q&A, and there are refreshments afterwards, so please stay afterwards and join us for a cup of tea and a chance to continue the discussion. So Declan, thank you.
Les, I'm grateful to the Commission for the opportunity to introduce the speaker at tonight's event. Most of you will see that Les is even more bubbly and enthusiastic than usual this evening. And the reason for that is that Les, like myself, is a dedicated Crusader supporter. And last Saturday we managed to achieve, for the third time in 4 years, the Irish Premiership. So well done us, Les. But it is my great pleasure also to introduce our speaker tonight, who is one of the United Kingdom's best-known commentators on the law. He is the only full-time journalist to have been appointed Queen's Counsel, and all the other honorees since the late 19th century have been practitioners or legal academics. He's written a twice-monthly column for the Law Society Gazette. He wrote a weekly commentary on the Guardian newspaper from 2010 to 16. He was the BBC's legal correspondent for 15 years before moving to the Daily Telegraph, and then took up a position as legal editor of that newspaper. And of course, after he left the BBC, he then returned in 2010 to introduce the Radio 4 series Law in Action. He has a particular interest in constitutional reform and is also published in relation to issues of freedom of expression. And to some extent, that may come into our debate tonight in relation to the title, Are Judges Enemies of the People? That, of course, arose from a ruling in the High Court of England and Wales in November 2016 that the government could not trigger the process of leaving the European Union without parliamentary assent. And the headline appeared in, of all places, the Daily Mail, surprise, surprise. There was vitriolic coverage, personal attacks on individual judges, and Lord Thomas, the then Chief Justice, told a parliamentary committee that it's the only time in the whole of his judicial career that he's had to ask for the police to give him a measure of advice and protection in relation to the emotions that were being stirred up. The title relates not just to the media, but also to politicians. And in this jurisdiction, of course, there has been a difficulty in the dialogue that should be taking place between the judiciary and politicians through the Justice Committee and the other organs of government hasn't been available. But certainly from our point of view, we have been anxious to ensure that we continue to have engagement with the political parties. And recently I had the 5 political parties round to look and discuss certain elements of John Gillen's Civil and Family Justice Review, and also a range of proposals that we had in relation to criminal law reform. And it is, I think, a sign of the times that the judges consider it now necessary to ensure that there is meaningful and regular political engagement or engagement by the judges with the political community in Northern Ireland in order to ensure that we are all working from the same hymn sheet in terms of seeking to move the justice system forward. Anyway, enough from boring old me. Can I ask you to welcome our speaker, Joshua Rozenberg?
Well, thank you very much. Thank you very much, Sir Declan. I'd like to begin by thanking the Northern Ireland Human Rights Commission and the Bar of Northern Ireland for inviting me to deliver this lecture. And I'd like to thank the Human Rights Commission for choosing the title. I'm sure the commissioners would defend my right under Article 10 of the Human Rights Convention to answer their somewhat provocative question in the affirmative, but after that very generous introduction from the Lord Chief Justice, I should say at the outset that no, my answer is no, the judges are not enemies of the people. Now, as he told you, that allegation was famously made in a newspaper headline some 18 months ago, the morning after the High Court of England and Wales decided that Brexit could not be triggered using the Crown's prerogative powers. The Daily Mail website went completely over the top, initially describing the Master of the Rolls as an openly gay ex-Olympic fencer. Perfectly true, but not entirely relevant. And the Daily Express front page comment is beyond parody. You're not going to be able to read it on that screen, so let me just read you a few extracts from it. Today, this country faces a crisis as grave as anything since the dark days when Churchill vowed we would fight them on the beaches. And then, if that's not good enough, it says later, truly, November the 3rd, 2016 was the day that democracy died. But it wasn't just the tabloids that launched personal attacks on the three judges involved. What used to be regarded as a serious newspaper, now much diminished, launched a rather more subtle attack on the then Lord Chief Justice of England and Wales, Lord Thomas of Cwmgyrth, the Master of the Rolls, Sir Terence Etherton, and the chap they brought in to write the judgment, Lord Justice Sales. These are official photographs. You can't see that clearly, but you notice they were printed in monochrome with a blue filter to make them look rather more sinister. And yet the opening paragraph of the Daily Telegraph story is pretty accurate, even though it's based on a fundamental misapprehension. It says, 3 High Court judges were yesterday accused of frustrating the will of more than 17 million British people after they ruled that Brexit cannot be triggered without a parliamentary vote. Now, contrast that with the Daily Mail story. It carries the byline of James Slack, who happens to be the Prime Minister's official spokesman at the moment, but like everything in the Daily Mail, it was inspired by the editor, Paul Dacre. The version of the story I'm going to read you has lots of adjectives and quotation marks. It begins like this. MPs last night tore into an unelected panel of out-of-touch judges for ruling that embittered Remain supporters in Parliament should be allowed to frustrate the verdict of the British people. The Lord Chief Justice and 2 senior colleagues were accused of putting Britain on course for a full-blown constitutional crisis by saying Brexit couldn't be triggered without a Westminster vote. The judgment by Lord Thomas, a founding member of the European Law Institute, a club of lawyers and academics aiming to improve EU law, throws into chaos Mrs May's timetable for invoking Article 50 in March next year. Well, it didn't throw the timetable into chaos, of course, and you might find it rather hard to remember what all the fuss was about. But the first thing I thought of when I saw the Daily Mail splash was a very similar front page published by another tabloid in July 1987, almost 30 years earlier. Same idea, 3 judges in wigs, but in what the Daily Mirror must have intended as the ultimate indignity, their pictures were printed upside down. This was the Spycatcher case, and the law lords had just ruled in those far-off pre-internet days that the memoirs of a former MI5 officer, which he had published in other countries, could not be reported in England and Wales. The three law lords in the majority were Lord Ackner, Lord Brandon, and Lord Templeman, intriguingly all captioned by reference to their wartime military service. I find it very strange to think that they were then the age that I am now. This is what the judges actually looked like, or at least that's what they looked like before they were promoted to the House of Lords. The Mirror editorial said there was only one answer to the injunction that the court had upheld: publish and be damned. Far better to risk being in contempt of court than to submit to contempt of democracy, it thundered. It was pure bombast, of course, because the paper did nothing of the sort. Back, though, to the Daily Mail in November 2016. You'll recall that the Lord Chancellor at the time and Secretary of State for Justice was Liz Truss. She was very reluctant to come to the defence of the judges. When pressed, she said it was not her job to condemn the newspapers. Well, indeed, it was not. But what she was being asked to do was to defend the independence of the judiciary, as she had sworn to do on her appointment. A more honest answer would have been to admit that she had been poorly advised, perhaps by Downing Street. Well, rather than press ahead with legislation, the government appealed. I don't know if you can see them, but these are the 11 members of the UK Supreme Court who heard the Miller case in December 2016, posing for the cameras and demonstrating that with a few modifications, they can just about squeeze round a table built for a maximum of 9. Interestingly, even though a majority of the justices upheld the earlier decision, they escaped press criticism. Now, why is that? Well, I can think of 4 possible reasons. Number 1, Liz Truss sprang to their defence moments after the Supreme Court gave judgment in January 2017. She described the justices as people of integrity and impartiality, suggesting that she realised her earlier reticence had been wrong. Actually, I don't think her comments on the case made the slightest difference. Okay, suggestion number 2, government loses Brexit case was a story we'd heard before. It was difficult to pretend that there was a constitutional crisis when the newspapers had declared one 2 months earlier and nobody had noticed. Reason number 3, well, the government was expecting to be defeated and was already talking about getting the necessary legislation through Parliament. I think that had quite a lot to do with it. And reason number 4 is that the entire hearing could be watched online, and quite a lot of it was shown live on the news channels with a running commentary. And I think that did have quite a significant impact on public opinion, persuading people that this case was decided on the legal arguments rather than politics. So, it's a shame that the earlier hearing in the Divisional Court in the High Court of England and Wales was not televised. If the Lord Chief Justice, the Master of the Rolls, and Lord Justice Sales had been sitting in the Court of Appeal, as they normally do, then the proceedings could have been broadcast under the current rules. In my view, broadcasting should be extended to make it possible for cases from the Administrative Court of England and Wales to be possible. Incidentally, the Lord Chief Justice of England, Lord Burnett, told us last week that 2 courtrooms in the civil division of the Court of Appeal would be live streaming appeals on the internet just as soon as the necessary arrangements could be made. Well, overall then, what effect has the Miller case had on the judiciary? Has it done lasting damage? That was a question raised by Lord Hodge, who's a Justice of the Supreme Court, in a talk he gave at Gray's Inn a couple of months ago. It wasn't a formal lecture, but he's very kindly agreed to let me quote his thoughts on the question, and here they are. First, the international publicity given to the UK's press coverage may have dented the reputation of the UK for the maintenance of the rule of law and the quality of its legal systems. I've heard foreign judges and lawyers expressing both surprise and concern, he said, but these things pass. Secondly, the suggestion, whether implicit or explicit, that the judges were consciously attempting to block the service of an Article 50 notice will have served to undermine the confidence of some, those who believed the allegations, in the impartiality of judicial decision-making. How serious that is, only time will tell. Thirdly, the events have done nothing to encourage lawyers to give up legal practice for a judicial career at a time when recruitment and retention of senior judges has become a very serious problem. That was confirmed, incidentally, by Lady Justice Hallett in a newspaper interview last week, and it's also a problem here in Northern Ireland. But finally, Lord Hodge does not think that the case has damaged the rule of law in the UK in the long term. We remain very privileged to live in these islands, he said. I agree entirely. Lord Hope, a former Deputy President of the Supreme Court, pointed out last month that successive governments have never failed to implement court judgments, however much they may have criticised them. 2 months after the Supreme Court ruling, the then Lord Chief Justice of England and Wales appeared before the House of Lords Constitution Committee for his annual grilling. Lord Thomas laid into Liz Truss over a claim that she'd recently made that the judges were unduly reticent, too reluctant to defend themselves in public. She reminded them that the so-called Kilmuir rules, under which the judges were not meant to give interviews, were abolished by the Lord Chancellor in 1987. I was there when the announcement was made by Lord Mackay of Clashfern. Liz Truss would have been 12 years old at the time. The idea that we don't realise that the Kilmuir rules have gone is quite frankly fanciful, the Lord Chief Justice told the Lords Constitution Committee. What the Lord Chancellor had not understood, he implied, was that no serving judge could have responded to the Daily Mail at that time without plunging the judiciary into political controversy. And it seems some people actually believed what they read in the newspapers. The circuit judges were very concerned, Lord Thomas said, because litigants in person were coming up to them and saying, "You're an enemy of the people." He also drew a distinction between media criticism and media abuse. Criticism is very healthy. If you've got something wrong, fine, but there's a difference between criticism and abuse, which I don't think is understood. It's not understood either how absolutely essential it is that we are protected, because we have to act, as our oath requires us, without fear or favour, affection or ill will. Now, you may know that judges in England and Wales don't get police protection of the sort that I see is still provided here. Last week I took the Underground from Westminster to Temple with Lord Burnett, the current Lord Chief Justice of England and Wales. As we crossed the road going towards the tube station, the Foreign Secretary was walking towards us, heading towards Parliament. Boris Johnson had 2 police protection officers, Lord Burnett had none. But his predecessor said, as you may have gathered from Sir Declan, his predecessor said last year that security had been increased, at least for a while, after the challenge brought by Gina Miller. Lord Thomas said the claimant had been subjected to quite a considerable number of threats, and it's the only time in the whole of my judicial career that I've had to ask the police to give us a measure of advice and protection in relation to the emotions that were being stirred up. Asked about the Lord Chancellor's insistence that it wasn't her job to censor or direct the press, Lord Thomas said she had been under a duty to defend the judiciary from unwarranted attacks. I regret to have to criticise her as severely as I have, he said, but to my mind, she is completely and absolutely wrong about this. It really is absolutely essential that we have a Lord Chancellor who understands her constitutional duty. After the general election, Liz Truss was banished to the Treasury. Time moves on. Last week, Lord Burnett told the Lords Constitution Committee that he had tried to draw a line under the Miller case and everything that followed from it. The Lord Chief Justice, who's now been imposed for 7 months, said he'd been very fortunate in both the Lord Chancellors he'd worked with during that time. He revealed there'd been discussions between officials, his officials and the Lord Chancellor's officials, about the possibility that the Lord Chancellor might have to step in the future on behalf of the judges. Happily, it's not been necessary for this Lord Chancellor to intervene, but we both have our antennae fairly finely attuned, Lord Burnett said. And there was no doubt that the Lord Chancellor now fully understood the constitutional position. Whatever the perturbations may have been in the relationship in the past, We're set fair at the moment, Lord Burnett said. Well, let's take stock. What lessons can we learn from the Miller case? Well, there's several lessons, I think. The first is that court judgments are now widely misunderstood. Even when the judges issue summaries, as they did here, people can still miss the point. One of the striking things about the Divisional Court's decision in Miller against Secretary of State for exiting the European Union is that at no point do the judges actually say that Parliament can get round the problem they have identified by passing legislation. That's implicit, of course. But maybe the High Court, unlike the Supreme Court, didn't want to tell Parliament what it could do. So there's nothing in the court summary to say that all that was needed was a short parliamentary bill, and certainly not could the court say that a bill was likely to get through Parliament without difficulties, as indeed it did. So I think possibly the judges might have explained their decision better to the public in the first place. What surprised me was how much notice the judges took of the newspapers. I know that the Daily Mail is still regarded as influential, and other papers took the same line, but it's only a newspaper and one that's increasingly out of touch with its readers, as you saw from its short-lived reference online to the Master of the Rolls as openly gay. The second thing that surprised me was that the judges expected the Lord Chancellor to come to their rescue. Of course, it would have been better if she had. But the days when the Lord Chancellor was the judge's shop steward in Cabinet ended when Lord Irvine was sacked 15 years ago, if indeed they ever existed then. Obviously, Lord Burnett disagrees, which is why he has the Lord Chancellor on standby to intervene. But look at the Constitutional Reform Act 2005. That makes the Lord Chief Justice of England and Wales and the Lord Chief Justice of Northern Ireland heads of the judiciary in their respective jurisdictions. In my view, it's now their job to deal with newspaper criticism. Now, you may think it would have been invidious for Lord Thomas to respond to the newspapers. It would have looked as if the Chief Justice was trying to defend his own judgment out of court, something a judge should never do. But I still think he could have done a bit more, an interview maybe, a press statement, or even an expanded version of the summary the judges had already issued. What actually happened was that after a day or two, his predecessor, Lord Judge, spoke out on his behalf, responding to a pretty vacuous statement from Liz Truss and describing it as a little too late and quite a lot too little. Lord Thomas did, in fact, get his own back on Liz Truss. He made it impossible for her to keep her job after the election last year, but I think it would have been better if he defended himself and his troops while they were still under attack. Well, that's enough on enemies of the people. Let me move on to the subtitle that you've given me, the current relationship between the media, the judges, and politicians. I'm going to start by talking about the relationship between the courts and ministers, and I'll then move on to the media's relationship with judges and politicians. 21 years ago, in the dying days of John Major's Conservative government, relations between the courts and ministers were not very good at all. Michael Howard was the Home Secretary, and he seemed to have the support of Lord Mackay of Clashfern, the Lord Chancellor. In a book I wrote at the time, I quoted a comment that Michael Howard had made on the radio about a High Court judge who'd just ruled against him. The Home Secretary pointed out that the last time this particular judge had found against him, his decision was overturned by the Court of Appeal. That judge was Mr. Justice Dyson, later Lord Dyson, Master of the Rolls, and he heard this over his breakfast cornflakes, but decided it was probably better not to respond. Relations are much better now. 2 weeks ago, MPs and peers questioned Lord Thomas, the former Lord Chief Justice of England and Wales, Lord Hope, the former Deputy President of the UK Supreme Court, and Lord Neuberger, recently retired as President of the Court, when they appeared before the Joint Committee on Human Rights. Lord Thomas, who was able to take his seat in the Lords for the first time after retiring from the bench last summer, confessed that until then he'd been ignorant of what actually happened in Parliament. It's quite different from what one would expect sitting on the bench, he said. Both sides needed to understand each other better, he thought, which is quite an interesting admission from a senior judge. And Lord Neuberger said this: there's no doubt that the past 50 or 60 years have seen an increase, quite a considerable increase, in the judicial involvement in policy matters. Most of these, he said, were not power grabs by the judiciary, but they meant that judges had a significantly more prominent and influential role. I like to believe, he said, and I do believe that, despite that, the relationship between the judiciary and the executive, and between the judiciary and Parliament, has remained one of serious mutual respect. While inevitably there have been more opportunities for disagreements, I don't think that either relationship has been harmed in any significant way. Asked whether the Human Rights Act had politicised the judiciary, Lord Neuberger accepted that judges had been required to make more policy-related decisions. But despite differences of emphasis on how much latitude the executive should be given, he said the courts were mercifully free of party political commitment in the sense one saw it in the US Supreme Court. But what about the UK Supreme Court, sitting in this very room until a couple of hours ago, and the other courts of the United Kingdom? How politicised, how activist are they? The Judicial Power Project was set up about 3 years ago by the think tank Policy Exchange. Its members, mostly academic lawyers, have dismissed recent rulings of the UK Supreme Court as decisions that confuse the rule of law and legality with the rule of judges. They accuse senior judges of claiming the right to second-guess and overturn political policy decisions by reference to how those decisions have turned out in practice. And the campaigners say that by interpreting the European Convention on Human Rights as a living instrument, the Human Rights Court in Strasbourg is acting in a way that involves brazen lawmaking. Well, Lord Neuberger was asked about this by the Joint Committee on Human Rights, and he said, well, there were some originalist judges, particularly in the United States, who thought it right to interpret a convention in the way it would have been understood at the time it was drawn up. Of course, in this case, that would be about 70 years ago, and that was not very sensible, he thought. On the other hand, if a court departed from the text as it was originally understood, that court was making new law. Lord Hope and Lord Thomas agreed that the Human Rights Convention had to be interpreted through contemporary eyes, while Lord Neuberger stressed the need for caution. Is caution what we'll see from the Supreme Court when it gives judgment on the case of McLaughlin, which it heard here on Monday? Or will the court turn out to be an interventionist lawmaker? I'll let you know what I think about that particular case in just a moment. The Supreme Court certainly wasn't cautious last summer. It upheld a challenge brought by Unison, the trade union, against the Ministry of Justice, deciding that fees charged to people using employment tribunals were unlawful because they effectively prevented access to justice. For the fees to be lawful, they had to be set at a level that anyone could afford, not least because many claimants had just lost their jobs. But the Justice Secretary, Chris Grayling, had put the hearing fees up overnight from nothing at all to £1,200, and as everyone but the Secretary of State had predicted, there was a sharp and sustained fall in the number of claims. So the order was set aside and the government was required to refund the fees already paid. The cost was substantial. But in my view, that was the right decision. Parliament could never have intended the minister to exercise his powers in that way. The leading judgment was delivered by Lord Reid, one of the two Scottish justices. Despite, or maybe because of his spirited dissent in a judgment delivered by the court this morning, I've tipped him to replace Lord Mance as Deputy President in June and to replace Lady Hale as President in 2020. We'll see. So, time to sum up the relationship between the judiciary and the executive. It's certainly better than it's been in the past. I think the courts are now very wary about trespassing on the preserve of Parliament, although we'll see whether that prediction is correct when we get the judgment in the McLaughlin case. And I think the politicians have seen what happened to Liz Truss So they'll be perhaps more wary about attacking the judges. Mutual respect for each other's position strikes me as the right way to proceed. Let me move on to the media's relationship with judges and politicians. I think it's possible for journalists to have a good relationship with both of them, although without wishing to appear too solipsistic, my own relationship with the judges is probably better than it is with politicians. I think that's because I, as a self-employed legal commentator, I'm probably not much use to ministers. If the Lord Chancellor wants to fly a kite or spin a future announcement, his special advisor is much more likely to give it to a journalist with no understanding of the subject who works for a high circulation newspaper. The first Chief Justice I knew was Lord Lane in the late 1980s. He never gave interviews while serving as a judge, but he did speak to me off the record. It was Lord Lane, of course, who dismissed the first appeal of the Birmingham Six in 1988. He was still in post when they were cleared in 1991. In my view, he didn't do enough to reassure the public that the notorious miscarriages of justice, which followed a series of IRA bombings in England, were being properly handled. That job fell to his successor, Lord Taylor of Gosforth, whose career was sadly cut short by ill health. And in his attempts to redress the balance, Lord Taylor went rather too far in the opposite direction, appearing, for example, on the BBC's Question Time programme. I've interviewed all the Chief Justices of England and Wales since Lord Lane. In recent years, they've all given annual press conferences. That's a good thing in principle, although the Chief Justices usually spend most of their time not answering the questions that we put to them. Their appearances before the parliamentary committees are much more informative, as you saw earlier. There have been rather more Lord Chancellors during the same period, and I've interviewed every one of those since Lord Hailsham, although in the case of Chris Grayling, it was what we call a doorstep, a question asked without the interviewee's prior consent. Chris Grayling was so difficult to speak to that one year I went to the party conference, the Conservative Party conference, at a drinks reception. The point about party conferences, it's the one place where the civil servants aren't allowed in, and so he has no protection. I sidled up to him at this reception just to find out what was going on. He didn't tell me, of course, but the following year I had written something disobliging about him on the very morning of the drinks party at the party conference, and the tables were turned. He sidled up to me and tried to put me right. I rather enjoyed that. If you'll forgive me for talking about myself again, I want to give you an example of what I regard as a healthy relationship between the media and the judiciary. Some of you may think otherwise. Earlier this month, I wrote a preview of the case which was heard here 2 days ago. It, as you may know, Mr. Justice Tracy held that Siobhan McLaughlin was entitled to bereavement support for her children, even though she'd not been married to their late father. The Court of Appeal here in Belfast overturned that decision, saying it was for Parliament, not the courts, to decide which benefits unmarried cohabitants should receive. On Monday, the Supreme Court reserved judgment on whether to declare benefits law incompatible with the appellant's human rights. Now, if you were to read my piece in the Law Society or Gazette, you'll see I spoke to the claimant's solicitor, Laura Banks, and she said it was neither fair nor lawful that Siobhan's children, or indeed any child, should be turned down for support when they needed it most because of the marital status of their parents. I described that as an enticing argument, but it was not an opinion I shared. This was how I summed up my thoughts. As the Court of Appeal said, it could interfere only if the government's policy was manifestly without reasonable foundation. That, it concluded, was not the case here. It may be tempting for Lady Hale and the other justices to downplay marriage and find the government's policy unlawful, but this is one occasion where temptation should be resisted. So, what do you make of that? Is that an appropriate thing for a journalist to say in a publication which is circulated to all solicitors in England and Wales? Or is it an improper attempt to influence a court when a case is sub judice? Before you answer, let me give you some more examples. As you know, coroners in England and Wales investigate deaths whose causes are unknown or unnatural. The system hasn't really been reformed for 800 years and is in a bad way. There is a chief coroner, but he has no real powers. This was one of 2 pieces I wrote about coroners at the beginning of this year. The picture shows Judge Lucraft QC, who's the chief coroner, And in the second piece, I said bluntly that Lucraft needed to get a grip of the situation in inner North London, where the coroner was facing judicial review proceedings. And the consequences? Well, Judge Lucraft did get a grip, although I think that was more because he was made a party to the case. And secondly, I was told that he regarded my comments, my criticism, as entirely fair and appropriate. He had no problem with it at all. Last Friday, the local coroner's guidance was declared unlawful and quashed by the High Court in London. I summarised the judgment in a tweet, and the BBC website republished it. But calling on the chief coroner to get a grip was still pretty tame in comparison with a piece I wrote just over a decade ago for the Daily Telegraph. You can still read a version of it online. The time has surely come for Mr. Justice Peter Smith to leave the bench, I wrote in 2007. A judge is nothing if he or she lacks judgment. But this is precisely the attribute that Sir Peter Winston Smith, 55, has recently failed to demonstrate. It's a long story and not one I plan to entertain you with now. Suffice it to say that Sir Peter Smith declined to follow my advice. Things went from bad to worse to appalling. And this is what I said a decade later. On the last 2 days of this month, an unlisted tribunal is planning to sit at an undisclosed location. The panel will consider allegations that have not been published and make findings of fact that won't be revealed. It's more than 10 years since I first called for Mr. Justice Peter Smith's resignation, but this piece is not about the misconduct allegations he faces. It's about the failure of the statutory disciplinary process to deal with those allegations in a timely and transparent manner. What were the consequences of that piece? Well, on the Friday before the tribunal was due to sit, it was announced that the judge, now 65, would retire the following day. Case closed. But let's go back to the piece I wrote in 2007 in a national newspaper under the headline, Mr. Justice Peter Smith loses his judgment. Could I have faced proceedings for contempt of court, as the former Secretary of State, Lord Hayne, did in 2012, after he published a memoir accusing Sir Paul Girvan, at that time a Lord Justice of Appeal, of high-handed and idiosyncratic behaviour? John Larkin, the Attorney General, who was in this room earlier today on his feet, he argued that passages in Peter Hayne's book constitute unwarranted abuse of a judge in his judicial capacity that undermines the administration of justice in his jurisdiction and consequently constitute a contempt of court. Well, leave was granted, but the case had unintended consequences. After Lord Hayne insisted that he'd not intended to question the judge's motivation or his capabilities, John Larkin dropped the case against him. Within less than a year, the common law offence of scandalising the judiciary was abolished here in Northern Ireland. England and Wales caught up a couple of months later. The offence still survives in Scotland, though, where it's known as murmuring the judges. In Singapore, by contrast, scandalising the court was put onto a statutory footing not long after, just so that people would have a better understanding of what the law allowed, as the minister explained reassuringly. Singapore law now says any person who scandalises the court by intentionally publishing any matter or doing any act that imputes improper motives to or impugns the integrity, propriety or impartiality of any court and poses a risk that public confidence in the administration of justice would be undermined, commits a contempt of court. The maximum penalty is 3 years in prison and a fine of up to $100,000, more than £50,000. Well, that's Singapore, of course, but there are other common law jurisdictions where it's risky to criticise judges. Take New Zealand. Last December, a judge cleared a defendant of violently assaulting the defendant's wife, his daughter, and a friend. The judge is reported to have told him, "There would be many people who have done exactly what you did, even though it may be against the law to do so. I consider that the consequences of a conviction are out of all proportion to what happened on this occasion." Well, an Auckland barrister called Kitriona McLennan, who's also spokeswoman for the local Coalition for the Safety of Women and Children, called for the judge to step down. She said, "His reported comments and the sentence imposed display a complete lack of understanding of domestic violence." And we learn from a subsequent blog post that the judge had been told by his senior colleagues that his remarks were indefensible and the acquittal was overturned on appeal. But we also learn that because of her comments, Catriona McLennan was facing disciplinary proceedings from the New Zealand Law Society. It was suggested that she had undermined the dignity of the judiciary. The Law Society of New Zealand then came under fire from another New Zealand lawyer practicing in London. He pointed out that legal commentators in England and Wales were able to call for the resignation of a serving judge in the most strident terms without adverse consequences. Indeed, some of us seem to have done rather well out of it. Time to sum up. The judges have to understand that journalists are not there to do their bidding. We're going to report what they say and do, even if they would rather we didn't. But calling the two most senior judges in the Judiciary of England and Wales enemies of the people caused huge damage to the judiciary, much more than the Daily Mail might have expected, and much more than I recognised when it happened. The attack came at just the wrong time and hit a raw nerve. That said, it is possible for journalists to have a relationship of trust with senior judges. We don't all break confidences. We don't all publish everything we know. One court routinely gives us embargoed copies of its decisions an hour or so before they're delivered. That makes it more likely we'll understand the judgments and report them accurately. It was a tremendous shock when I moved from being a law student to a law reporter and found that judgments were delivered without headnotes. In an appeal, you had to work out which side was the appellant, which side was the respondent, and try to spot key words such as allowed and dismissed. In 1985, I was given an advance briefing by Lord Scarman, one of the law lords, ahead of a judgment he and his colleagues were about to deliver that afternoon. It turned out that two of the law lords had voted to allow the appeal, two of them had voted to dismiss it, and the fifth judge appeared to support both sides. Lord Scarman wanted to make sure that I correctly reported on the radio who'd won. As just a few of you may remember, it was not Mrs. Gillick. Don't forget that the judges use the media just like everybody else. Judges give interviews from time to time, judicial press officers tweet judgments, the Supreme Court live streams its hearing on the internet, and as I said, the Court of Appeal in England and Wales is planning to do so too. I conclude where I began. Judges are not enemies of the people. Abuse of the judiciary or of anyone else should never be tolerated. But I hope I've persuaded you that we in the media, as well as the politicians, can and should maintain a respectful but robust relationship with Her Majesty's judges, reporting not just their judgments, but on rare occasions, their misjudgments too. Thank you very much.
Joshua, thank you. There has been an outbreak of populism with the title of this particular lecture, but even I didn't expect quite the wide-ranging review of the position. I heard everything from the importance of open justice and the media being in courts, an issue that the Civil and Family Justice Review considered very carefully in this jurisdiction very recently, through to the modern role of a Lord Chief Justice, through to understanding of parliament from judges and vice versa. So I can't believe that we won't have a number of questions. What I intend to do, we've got 15, 20 minutes at most, is to try and take them in batches of 2s and 3s. We have a roving mic, so if you'd like to ask a question based on what you've heard, please put your hand up and we'll come to you, say who you are, and then we will do justice, hopefully, to your question. So,
very interesting question. Thank you very much. It's very interesting working out how you're running your country without a government, and how long it can go on for, and whether, of course, you're better off. But that's not what you're asking me. What is interesting to me is what Declan Morgan told you at the very beginning, which is he had meetings with the 5 political leaders here, because he clearly thinks that that's what needs to be done in the absence of a government. I don't know what happened at the meeting, but at least he heard from them and they heard from him. And that seems to be a very wise thing to do in the circumstances. There is a difficulty, isn't there, if you don't have a government, and the courts must feel the need to step in, because otherwise there is a risk that things simply won't happen. Obviously, civil servants have extraordinary powers here, and permanent secretaries and so on can do things. And you know, the business of the state carries on without a government. I don't. Sorry about the howl round. I think the howl round is probably from the microphone that's. Can we switch off the one that's in the room? That may possibly be better, and if not, I'll do my best. The real question that I am very interested in, and this is what I was touching on when I was talking about this McLaughlin case, is who's to decide, and it's easier when you do have a government. The point about the McLaughlin case is that the government of the United Kingdom effectively decided a couple of years ago that children of bereaved cohabitants were not going to get this benefit. It's argued that this is discriminatory and therefore it's unfair, and therefore they should make a declaration of incompatibility with the Convention, and therefore it should be changed. But it's argued against that Parliament has made this decision, and therefore the court shouldn't interfere. And it's a very difficult balance, and it'll be very interesting to see what the court decides. And you know, and that's why I mentioned the other case. That was the Unison case over the employment tribunal fees. And so what I'm really saying is that it's quite a dilemma for the courts to decide how to act. I suppose I have to say that if there is no government here, then courts should be even more cautious about interfering, because the one thing that reassures judges in a normal political setup is that if they do something that's really wrong, as far as the government's concerned, then in principle the government can get legislation through and overturn it. That's the one thing that reassures judges in normal circumstances, and it's perfectly lawful for the government to say, well, you've ruled against us, but we're going to overturn it. Of course, judges may then try and challenge that legislation effectively, but nevertheless the government has the last word. Parliament is sovereign. Except, of course, in EU matters, and we know what's happening there, and to some extent Strasbourg, but the government's capable of coping with that as well. So I think it is a problem if you don't have a government, and I think the courts have to be that much more cautious. Do the newspapers have an agenda and an ideology? They certainly do. And of course, the reaction to the judges was nothing to do with their judgment. It was to do with the fact that the newspapers purported to think that what the courts were doing was blocking Brexit. And these were the pro-Brexit newspapers, and they thought the judges were getting in the way. The judges saw it completely differently. The judges thought that they were giving the power to Parliament to decide something which the government seemed rather reluctant to do. The judges were saying to Parliament, well, you know, you go and vote on this. If you vote for legislation, it will go through and Article 50 will be triggered. If you don't, you don't. We, the judges, think we are taking power away from ministers exercising their prerogative powers and handing them to members of Parliament who must vote on legislation. That's what the judges thought. But as far as the newspapers were concerned, as you saw, the judges were blocking Brexit, and that was unconstitutional. It was an unconstitutional crisis. Now, whether the newspapers believe this or not is rather hard to say. I mean, there are certainly some intelligent people working for the newspapers, and some of them can work it out. But they perceive things through a particular lens, and crucially, they understand that their readers see things through a particular lens, and they like to feed their readers' prejudices. Ben asked about recruitment. Recruitment to the judiciary, certainly in England and Wales, and I think here, where I think you're You have 7 High Court judges with a complement of 10, so you're 3 down if my figures are up to date. Recruitment is a major problem. There's 16 down in England and Wales out of a complement of about 100, and they cannot recruit enough good people to join the High Court in England and Wales, and as far as I know, here as well. And that is because, to quote Ben's phrase, it is not seen as prestigious anymore. You think, why do I want to do this? I'm doing perfectly well at the bar or as a solicitor. Do I really want to be described as an enemy of the people? Do I really want to be criticised? Do I get much prestige as a judge? Think these barristers. Do I get much money as a judge? One of the problems in England and Wales is that one of Grayling's reforms changed the judges' pensions, which is one thing that self-employed judges wanted to join the bench for, and it is now, you actually lose money if you're a barrister or a solicitor in England and Wales, particularly a barrister with a self-contributory pension. You actually lose money in terms of your pension if you take the state pension as a judge, so that if you join the bench now, people just don't take the pension that's on offer because the tax position is such you actually are worse off. So the Lord Chief Justice of England and Wales is very concerned about recruitment to the bench, and they're doing all their best to tell people it's their duty and that it's a very fine thing to do. But just as people in all walks of life don't really want to go into politics because all political careers end in failure, there are an awful lot of people who are now just saying, I don't want to be a judge. Joshua. Okay, let me start with the second one, the Cliff Richard case. Is it possible for me to comment on a case which is before the courts? I mean, yes, of course it's possible for me to comment. Is it possible for me to comment about a case involving the BBC for which I used to work on the staff and still do freelance work? Yes, of course it is. I think the BBC is right to fight this one. I think the BBC is prepared, if it loses in the High Court, to appeal and take it as far as it can get, even to the Supreme Court. I think the reason for that is this, and I understand closing speeches are next Tuesday, but from what I understand, Cliff Richard is arguing for a very simple thing, but a significant change in the law, and it dates back to, and it feeds into the question I was asked first. Cliff Richard is naturally concerned about the intrusive publicity of his home. If I was trying to analyse his thought processes, I would imagine he was more concerned about being accused in the minds of the police or the public of being a paedophile than having pictures of his home when he wasn't there shown on television. I think it's transference of concern, but I respect his concern. But what he's asking the courts for is that the BBC, and by extension all journalists, should not have reported the police raid on his home. They should not have reported that the police wanted to question him, that he was a suspect, at the very least, unless or until he was charged. And the BBC's position is, if we ignored the fact that somebody like Sir Cliff Richard was being questioned by the police or under suspicion by the police to the extent that they got a search warrant and searched his home and searched his papers and so on, that would damage public confidence in the BBC, given how the BBC failed to report the Jimmy Savile case, which was going on underneath their noses and which they ignored. And therefore, I think the BBC was right to report the police investigation. I'm not going to defend the pictures or the way it was handled or the scoop or the congratulations email and all that sort of thing, which was a bit tacky. But the serious point is that if Cliff Richard wins his arguments, the law will say we can't report people under investigation. And that feeds into the second part of the question that I was asked previously, which is about the age of social media. Because if the BBC doesn't report it, you can be pretty sure other people will these days. And they're going to say, why isn't the BBC reporting it? And broadening that point, why are things available to the public through social media and not through the mainstream media? which brings me to the question about publicity in sex cases, rape cases, and so on. The last possible thing that I would like to see is trials conducted in private with the press and public excluded. I would do everything to avoid that. You asked me about anonymity for defendants. Curiously, that was something that was tried in England and Wales for a while and then abolished. It was brought in at the same time as anonymity for complainants because an MP said, well, if it's fair for her, it's fair for him. But after a few years, Parliament reversed it. It's one thing in the Irish Republic to say that's what our law is, and I know from you, you say it works quite well there. It's quite another thing to introduce it in part or all of the United Kingdom, given where we are now. I think it would be very difficult to introduce. If there are problems in these cases, then I would recommend a number of special measures to reduce the problems. So, for example, obviously a complainant can give evidence behind a curtain. A complainant can give evidence on a video link so that she, and usually she, wouldn't be able to hear the muttering in the courtroom when she gives her evidence, even though the courtroom can hear what she says. If that is too difficult, I would certainly consider pre-recorded evidence in chief and pre-recorded cross-examination. If there is a risk of her name being read out and then reported on social media, as obviously there is, then I would say don't publish her name in court, refer to her as the complainant, refer to her as a pseudonym. I'm not saying that that would make it impossible for people to find out who she was. In a small country, people would know and it might be published. In that case, you prosecute people for contempt of court and you send them to prison and you send out a message. The answer is that we should preserve the freedom of the press to report what is going on, because if we don't, in the age of social media, people will get an idea of what's going on, a false idea of what's going on, a partial idea of what's going on, and they will be less well informed about what the courts are trying to do. The message from the Lord Chief Justice of England and Wales is to open the courts as much as possible. The reason the UK Supreme Court was here was to bring the court to the people and let the people see how the courts worked. The reason that the UK Supreme Court didn't have the bad publicity that the High Court had was that people could see what was going on. We certainly don't want to go in the other direction.
Okay, I think our time is up. I'd just like to, first of all, thank Joshua for a wonderful, stimulating lecture. I suspect we could have taken most of a day to unravel some of the issues that were raised, including judicial activism and the Human Rights Act and various things that are dear to a Human Rights Commission's heart. I'd like to thank the Bar of Northern Ireland, who's both sponsored this lecture and who have partnered with us for all three lectures, particularly David Clare and her team, who have made this a seamless event, particularly given that we've turned what was the Supreme Court this afternoon back into something of a lecture theatre this evening in double quick time. Please stay and enjoy some refreshments, a chance perhaps to carry on some of the conversations with Joshua. Thank you for coming this evening, and safe home whenever you decide to head home. Thank you very much indeed.